There is Janet. Welcome to the show.
Thank you, James. Nice to be back on your show. We've got a lot to cover today. So let's just sort of charge into it, huh? I want to bring the listening audience's attention. The Wall Street Journal published an article, good grief, a bit of time ago concerning the least transparent administration was the title of the article. Once again, this is the Wall Street Journal. And the article is basically stating that that the Obama administration is the least transparent administration in terms of responding to inquiries from the public, and also actually from, according to the article, from the House itself. House Oversight Committee is cited here as also being stonewalled by the Obama administration. I'm going to read a couple of sentences here from this article, and then we're going to go into how this is playing out on a local level. It says, most administrations play games with FOIA, but the Obama White House has turned stonewalling into an art form. A favorite tactic is to ignore or string out the requests. The article also states here that FOIA requests, Freedom of Information Act requests backlogs have more than doubled since President Obama took office. It says here, another trick is to impose sky-high fees. Most disturbing are examples of destroying or hiding information. So these are, fairly strong allegations, and they are coming from the Wall Street Journal, not from conspiracy.com. Okay, so very recently it hit the news that a reporter in Louisiana was actually arrested for making a Public Records Act request. Now, we have a video on that, and we're going to run that video so we can see how this exquisitely, really appropriate TV news reporter was taken into custody for trying to file a bona fide Public Records Act in a small town of Louisiana. You got that video there, James?
Yeah.
News 2 at 6.
This is what the residents of White Castle deal with.
Chief Investigator Chris Nakamoto detained and charged while trying to get public records. Good evening. Chris has been reporting extensively on the White Castle mayor and how he received a large pay raise.
Continuing his coverage, Chris went to White Castle today to obtain a missing part of his public records request. Instead, he left with a criminal charge. This is what the residents of White Castle deal with.
Cuffed, charged, denied public records, and told never to come back, all while doing his job. Around 11 a.m., Chief Investigator Chris Nakamoto and photojournalist Joe McCoy arrived at White Castle City Hall to get one missing part of a public records request Chris filed with the city of White Castle Monday. It was a three-part request. Chris wanted copies of an ordinance about Mayor Jamar Williams' salary, an audio recording of Monday's town council meeting, and a copy of his car mileage compensation paid by the city to Mayor Williams. The News 2 investigative unit has reported extensively on allegations Mayor Williams' salary increased $22,000 over the course of a year, and if it was done properly. In order to investigate those allegations, Nakamoto must follow the money through a paper trail and interviews with various city leaders. Back at City Hall late Wednesday morning, less than 10 minutes after Nakamoto walked into the lobby to ask the city to fulfill the missing part of his request, he was back outside, empty-handed, without the public record he's entitled to. He asked his photographer to join him inside to document the lack of transparency.
Can you get Ricky to come up for us?
This time, most office clerks weren't available. Most walked to the back of the building and out of the camera's view.
Oh, you gonna come back when the camera leaves?
And about 15 minutes later, one person escorted a White Castle police officer from the back and into the lobby. He turned around and eventually entered again to confront Chris.
How y'all doing?
Hey, good. How are you, sir?
Good. Let me have y'all step out here for me.
For what?
Go ahead.
For what?
Because you know you guys need to come.
We have a right to be here.
So, I'll let y'all step out. I'm asking you to step out.
on what grounds?
They asked me for you to leave the premises.
Okay, this is a public building, sir. We have a right to be here. I put in a public records request, and we have a right to be here. That's the bottom line. I'm here to get our public
Please stop
records.
recording.
News 2 didn't stop recording because in a public building, anyone is well within their right to record in a common area such as the lobby. Chris asked again why he needed to leave.
Yeah, you guys leave.
We're not leaving.
You're not leaving. Okay. All right. Well,
Excuse me.
I did ask you nicely. So, in that you are refusing to leave. Okay. So, I have to put you under arrest for remaining after being forbidden.
Okay, go ahead. We're in a public building. We're trying to get our public records. Simply ask them to give us our public records. So if you want to arrest me, go ahead.
And the officer did.
Go ahead, put your hand behind your back.
Chris was whisked away.
And so what are you arresting me for?
Because I actually
Okay. Next door to the White Castle police station.
No, I actually stay out here.
Sir, this is a public building too.
Still in cuffs, Chris was escorted inside. Our photographer was denied access, and the door was shut behind them. About an hour later, Chris was released. He received a criminal charge for trespassing in the lobby of a public building while trying to obtain the public records anyone has the right to get.
I think that's actually a stunning representation of what's actually happening to individuals who are attempting to confront, even obtain public records. All right. As we have discussed before on your show, we have now an activist named Carrie Andrew Crittenden sitting in Santa Clara County Jail on concerning circumstances that we can't find out. We can't find out why Carrie's in jail again. Now, previously, he was cited for harassing public officials by making internet postings about them. He served some time. He was rearrested on a probation violation when he was approached by officers. He was sitting in Starbucks. The officers demanded the password for the computer in front of Carrie, which was not his computer, and he basically alleged that he had no legal responsibility to provide the password to somebody else's computer, and he was arrested on that. Now he was arrested again on Christmas Day, and we can't find out why. So in the course of making Public Records Act requests, these requests were forwarded to an assistant district attorney named David Angel. The relevant laws which govern the release of this information when a person is in custody. We want the police reports. We want the factual circumstances surrounding the arrest of Carrie Andrew Crittenden, and the DA won't release them. So we filed a complaint, an official complaint about Assistant District Attorney David Angel with a Lieutenant Jose Perez, who is an investigator with the DA's office. That complaint has been sequestered. We can't get any response as to, what sort of investigation, what is the determination of that complaint. So this week, in a fit of just throwing up my hands, I contacted Fox News in San Francisco, explained to them to the reporter, his name's Jesse Gary, what was going on, and forwarded to him the complaint that was filed against Assistant District Attorney David Angel for refusing to adhere to the Public Records Act request. Well, I got a response back. Jesse Gary was very interested in this. He contacted David Angel right away, and he responded to me. And I'm going to read this response because it's outrageous. He writes, that would be ADA David Angel, says, there are mental health implications in this case. So that could be part of the holdup on detailed information. If you're not next of kin, it may be difficult to more info. Now, the fact is, we're not asking for mental health information about Kerry Andrew Crittenden. In fact, we found out from his father, Ken Crittenden, who attended one of these hearings involving Kerry, that while Kerry has steadfastly refused to submit to a mental health evaluation, they had a doctor trot himself into court, a doctor who did not interview or examine Kerry and declare him to be incompetent. Now, this is a setup. So I responded to Jesse Gary in an attempt to urge him to move forward with this. And I explained to him, we're not asking for mental health information about Kerry. We want to know why he's in jail. What was he supposed to have done? Now, this is the core of the concern. California law, as expressed both in the Public Records Act and in a court case called Kuzar, basically mandates that if a person is in custody, this information is releasable. And Kuzar explicitly states that this information is releasable to the public upon request in order to obviate concerns about secret arrests. And what do we have in terms of Kerry Andrew Crittenden? We appear to have a secret arrest. We cannot find out why he is in custody. So, do you have a call in waiting there, James?
Yes.
Okay. I'm going to give a brief synopsis of why this individual is calling in and how this new case involving yet another guardianship activist who's sitting in jail. Kerry Andrew Crittenden, who's a guardianship activist, is in Santa Clara County. We now have a very strong and well-respected activist named Tim Larman, who is a certified paralegal, who is sitting in jail in Goshen City, Indiana. And the circumstances surrounding Tim Larman's arrest, he was arrested on a 17-year-old warrant on a misdemeanor, 17-year-old warrant. I'm going to repeat that. He's sitting in jail without bail. And Ken Dukowski, who is has been on this show before and has done an amazing amount of yelling and screaming about corrupt guardianships, is going to be on to kind of give us a synopsis about Tim, and we're going to be discussing this. So let's bring Ken on now. Thank you, James.
All right, welcome to the show, Ken.
First thing is, on the Crittenden case, if a man is mentally incompetent, he shouldn't be in jail. He shouldn't be in jail at all. There are other facilities for him. Now, as a Tim Larman, this is an outrageous situation because Tim was arrested on warrants that are 17 years old. There was an attempt to renew them, but you cannot renew misdemeanor warrants, and you certainly can't renew them long after they've expired. It's not a situation that's allowable. If a man was arrested at the turn of the century, you can't wait 10 years to prosecute him. And the same argument applied to the situation of a speedy trial. If you don't have immediate trials and immediate action, you don't have due process. Now, there are exceptions when someone leaves the United States. If he flees to Cuba, as an example, it would be stayed. But Tim was within stone's throw of the courthouse. So you have an entirely different situation. And then if you go back and you look at the records that recently have come to light, it appears that Tim was arrested originally arrested on a marijuana charge. And there's in the file a report from the crime lab, and the crime lab found marijuana. Well, that's wonderful, except if you know anything about marijuana, you also know that marijuana is called hemp, and some of the finest ropes are made from hemp. So the distinction has to be: did Tim have hemp, or did he have a substance that's banned? Well, the report says marijuana. That's not sufficient. It has to say the substance that's illegal, and which would be cannabis. Since it doesn't say that, it's vague. Now this, of course, comes up before a judge. A judge has a specific obligation, and this obligation is absolute. A judge has to make sure that every citizen gets due process and justice. This means the judge is not an advocate. He is an instrument of justice, and he has to make certain that every element of the crime is proven beyond a reasonable doubt. If any element is not proven, he has to throw it out.
I'd like to jump in for a sec. Can I jump in for a second here, please?
Sure.
I have recently, thanks to Candace Schwager, attorney, request here, I have received also some of the public records pertaining to Tim Larman's arrest back in 1997, was it? 1997, 1999. And according to the records, it specifically states that, that a summons was issued to him for his trial, which was to take place at a certain date, and the summons was never served. Now, I know that some of the lawyers who are on the list, paying attention to what's happening to Tim, have some questions about how important that is. But I do note that some of us are concerned that that due process could not have been served if an individual who's charged with a crime is not even informed of his court date. So I wanted to bring that.
You're absolutely right. That if he's not informed of the court date, not brought before the court, which the summons would do, due process cannot occur. However, if Tim appeared in court, and it appears he might very well have, because he fired his public defender, and to fire the public defender, he had to appear in court, which would waive the summons. Now, the record is not clear if they gave him any notice after he fired the public defender or not as to the trial date. We know he didn't appear. But as I started to tell you, it doesn't make any difference, because the record itself shows that they could not prove beyond a reasonable doubt that Tim had possession of marijuana. They had to show that he had the cannabis in his possession. The report does not show that. Now, in the United States, we have a presumption of innocence. So that the court has to look at this using the presumption of innocence. It can't say, okay, they said marijuana, ergo, that's sufficient. That's not sufficient. It had to be cannabis. It had to show the wrongful stuff. Now, assuming that they brought in a lab technician to testify, and they asked him, when you say marijuana, what do you mean? And the lab technician said, I mean X, Y, and Z. That's barred also because of the Brady case. You have to give the defendant the evidence that you're going to present in court. That's part of the due process proceedings in criminal courts. And Brady has said that if you don't bring it in, it's barred. And they didn't do it. There's no evidence of them doing it. In fact, the evidence is that they didn't. So this is all part of it. Now let's assume for the moment that the summons thing has some issue. That might be a burden for us to prove. And it's much easier to deal with a situation where we have clear and convincing evidence that things are wrong. And they're not only wrong by the judge not doing his job, but the prosecutor is also not an advocate. The prosecutor has to see justice is done. So the prosecutor has to make sure that the Brady requirements are in fact met. They didn't do that. So that's a violation. But let's go a step further. Let's assume that everybody does what they're supposed to do, the judge says it, the prosecutor does it, and I'm appointed the public defender. And I don't do my job. The courts have ruled that if I don't do my job, the incompetence of counsel would give a right to a new trial. So we have 3 strikes, and all 3 strikes are met, and they're of record, and there's no question that the court in Gosham City, Indiana, has no alternative if it is not wired to dismiss these proceedings and released him from jail. In fact, he should never have been jailed. The judge should have seen this. And one of the very serious situations is the fact that apparently they appointed a public defender. The public defender is either on vacation or going on vacation and never even bothered to contact him or make any arrangements or file any motions. So we have a very, very clear case of attorney malpractice on behalf of this public defender. She didn't do anything whatsoever. She didn't have the time to meet with Tim. Then there's one other thing that's kind of amusing. I've been practicing law for...
Can I bring up something? I'm sorry, can I bring up something very quickly? Thank you. Yeah. As it turns out, this case against him, which involved the marijuana and also, I believe, there were 2 charges. The second misdemeanor charge was driving with a suspended license. After they failed...
Which expired 18 months afterwards.
Right. So what happened was, after they failed to summon him to court, failed to serve him with notice that his trial was taking place, according to the records that have been retrieved, what happened was that the court impaneled a jury and tried Tim in absentia, sentenced him to 2 years in jail. That's a fairly hefty sentence. So
especially on a misdemeanor.
On the misdemeanor, right. So all this happened 17 years ago. And when Tim was picked up just a couple weeks ago, this is what he's facing now. He's being held without bail on this stale issue. I do want to also just simply stress that...
Pull your mic back.
Tim has been absolutely amazing.
A little closer.
Can't hear you.
A little closer now.
Tim has been working as a paralegal and helping people all over the United States with their guardianship matters. And very recently, according to Robin Gibson, whose mother was under a guardianship in Los Angeles, it was Tim's paralegal work that was responsible for getting her mother out of the guardianship. He has helped numerous people. So
the fact is that Tim was operating right in the court system that these same people are dealing with. They could have arrested him 17 years ago, but they chose to wait all these years. We go from, it's 2016 already. All these years went by, and they did nothing. That's a pretty clear indication that the charges were pretty bogus. And this goes on, and 2 years in jail on a misdemeanor charge is absolutely absurd. But we know why this occurred. There's no question why it occurred. Tim's guardianship was brought by his brother, who wanted to terminate a partnership. And terminating a partnership is sometimes very difficult and time-consuming. So he solved the problem by having Tim declared incompetent, by having him declared incompetent, that allowed a guardian to come in, and lo and behold, the property was sold and sold out from under Tim without him having his day in court. Now, this guardianship also does something, and this is the same thing that's true in your Crittenden case. If a guardian's appointed, to the extent of the guardian's authority, no one can proceed against the individual, the ward, without the guardian being made a party to the situation.
That's right.
Now, what they have been doing in most of these situations is not limiting the guardianship. If you're designated for guardianship, you lose all your rights, everything. The guardian takes over your life, which is a clear violation of the 5th and 14th Amendments as well as the 13th Amendment. You can't do that. But they're doing it. They're doing it on a regular basis. Now, when the guardian's appointed and this is met, this becomes the law of the case. Right, wrong, or indifferent, this judge has subject matter jurisdiction, and therefore, having subject matter jurisdiction, if he forfeits your rights are forfeited, even though it's wrong. Now, you can do something about it. You can file a civil rights suit. You can complain to the Justice Department under ADA. But the rule of the law is you are an incompetent. You have no ability. Now, if Tim had no ability, he couldn't have the scienter necessary to commit any crime.
Well,
and the judge
also,
knew or should have known that, because the judge is charged with knowledge of the file and of the individual. A judge doesn't sit there as a prima donna. A judge has affirmative responsibilities. The prosecution has affirmative responsibilities. And
there's nothing. Wait, I have to say something here. Ken. There's nothing in Tim's file, as retrieved by Candace Schwager, that indicates that the guardian was in any sense brought into these misdemeanor proceedings against him. Correct?
Then
Correct.
The proceedings are nullities, void, and there's some liability on the part of not only the prosecutor, the judge, and the PD, because they didn't do their jobs. They're not there to look pretty. They're due to protect the public, and they've taken these responsibilities. This is part of the reason the Illinois governor went to jail, because he didn't follow his responsibilities. He cheated the public by accepting money from the state and not providing services. And these people deserve the same thing and ought to be punished.
Well, I think I want to thank you, Ken, for coming on and discussing and giving this illumination into the case. I think this is a very important case that's going on, and we're all actually very concerned about Tim's rights, as well as everybody else who's being deprived of their rights through guardianship court.
Well, this could happen to anybody. Anybody is targeted, and it's got to be stopped. We've got to go back to the rule of law and have respect for the Constitution and our core principles.
Amen to that.
Amen to that.
Amen.
Well,
amen. Okay. I'll get off now.
All right. Well, thank you very much, Ken, for your
thank you.
Your informed information.
You're certainly welcome.
Thank you very much, Ken.
It's good to hear from him, because he really knows what he's talking about.
Yeah, he really knows what he's talking about, and I think he's really highlighted some of the very concerning parts of this situation, which is, first of all, you have an individual who was put under guardianship in order to rob him. The guardianship was never terminated, and you fast forward to 1997, and the individual gets charged with a misdemeanor, does not have the guardianship seems to be it is not dealt with by by the criminal court. In fact, I've seen the records, and Tim certainly advised the court of the guardianship and the implications of it. Furthermore, he's not summoned into court. He's tried in absentia. He's given a 2-year sentence for this misdemeanor and then arrested 17 years later. I mean, how much worse does it get? So on this note, I'm going to say so long for today. I want to thank you very much, James. I want to thank Ken for calling in. And, Viva America.
Well, we do have up on the video the New Eastern Outlook, which is where you can find Janet and her stories, and you can also look her up on Facebook, Janet C. Phelan, and communicate and so forth. So again, I appreciate your work that you're doing, Janet, and we will talk again.
Thank you, James. Have a great week.
You.
Bye-bye.